I don't know. The time is how I could pay them back at the moment. Hopefully, it's something more that I could do once I get out, if they let me.
Is the lady that's your child's mother, is that the same person you were dating then?
Yes, ma'am.
So you did it because why?
Nah, that's what I don't want to. I don't want to go back and explain it.
I'm not, it was obviously a lie.
If that's what.
Was it the truth?
Like I said, I don't really want to go back and explain it. It's not really.
So here's how I think.
May I just say this? Okay. That's a real good question. But what he was dealing with was he received the news that she had been sexually assaulted. There was, I mean, it's still an overreaction, but he obviously called somebody a number of times. Call. The only thing that we'll all agree upon about this case is that this was some excellent police work. What are the chances that somebody beyond the line of fire gets struck 4 times exactly? I mean, and he's in a closet fixing something and had nothing. That's just so, it's so everything was. The fact that he got caught, the fact that nobody else that he was shooting at got hit, all of this. You understand what I'm saying? Everything. And then, did she get raped? Did she not get raped? The whole thing is something you could actually write a book about. It's sad. His life is over. The victim's gone. The victim has grandchildren. The baby who's in the hallway, I mean, right there. I mean, it just makes you just sick. And I don't know. But that so I had a talk with him where we finally went from top to bottom exactly what happened. I couldn't finish the phone call. He couldn't either because he was so upset about it. And he said, I'm ready to get it over with. And this was a tribal case. I want you to know that because when you look at the video and everything, all the officers that responded before said, you know, the messages we're getting and the reports we're getting that there was a bunch of kids shooting guns at each other. I mean, if that's not a tribal case, you know, Fulton County, all it takes is one. And the state will try it again and try it again and try it. But he told me, he said, I'm ready to get it over with. He has never told me that he did not do it. I got him out. I got him a bond. Miraculous. I got him a bond. No violations. Another miracle. But I don't know if that answered your question, but yes, he's still with the young lady and they have that 7-month-old child now. The only way that we could change any of this, Adam, and you know, this is negotiated plea, but if the court doesn't have to take the plea because we suspended the 5 years afterwards on probation, is the court adding a condition that at some point he takes care of the funeral expenses, or at some point he does this. He knows when he goes into jail that he's going to complete his college. He knows to sign up for every single thing that he can while in jail. And he's not, thankfully, looking at a life sentence where you come back in 32 years for your first consideration for parole. And they usually vote to set you off. So, I mean, and he could have gone to trial and got life without parole. So in a sense, he's very, very grateful for the sentence. But if the court is concerned about something back to the family, I could not get him into anything, Judge, because we couldn't even get him to where he could go for a job. And Miss Kelsey Jones Connor did say that she would think about him having a job, but she wanted it to be an at-home job. It was just, everything was impossible. I had promises, broken promises about them going to the house, delivering computers, doing this, training him, all that. Anyway, but to that extent, Judge, he's happy to do anything that he could give back to the family, other than, I know you can sign up for anger management while in prison, college, skills, all kind of certificates you can sign up for, and he knows to do that, Judge. So I don't know if that helps you at all, but that's what we've tendered to the court as far as a plea. The court can change it and ask the family about any expenses they've incurred.
You'll have an expense for the funeral, I didn't think.
No, we don't want any.
I mean, I'm sure this, I don't think you could.
I mean, no, there was an expense.
Right, I don't think you-
Yes, it wasn't a free funeral, wasn't
Yeah,
a free, nothing, you
Yeah,
know. yeah.
That's the thing, is I don't
I don't have an exact number, but I could come up with one, I mean, if you want me to, but I don't have an exact number right now of how much the funeral costs.
I know it was probably 20 grand, I don't think you could get out of a funeral without spending 20 grand or.
Yeah,
Or
right.
more.
Judge, I'm going to do two things, if I could. First of all, I am going to suggest just a brief modification of probation at the end, with the court determining at least a funeral expense. I'm also very familiar with the victim witness advocates at this office. They're incredible. And there is a fund that after the case is over, that the state can also assist the victim witnesses. And I know that they will give the family that, not only the number, but they assist them in getting some type of, it doesn't do anything, Judge, but at least it's, that was not something that's not anything extra they were planning on that month, to say the least.
Back to what I was saying, it appears that all this started because of possibly a lie. I didn't hear that Mr. Ware called 911 at any point in time, or that he took it to the hospital, the police department, so she could make a report. I didn't hear that. And that's what I was waiting to see, so. All I could sit here and think is, look, and like you said, like Ms. Woodman said, this is just a statistic, it should not have been. Did the other people that were shooting at people, were they indicted on something? Oh, okay, so there was no one else shooting, it was just.
Well, I wasn't there, Judge, neither was Mr. Abate. I just had to watch hours and hours and hours.
Thanks.
They are right in.
Yeah. Judge, are you ready?
I'm ready, I'm ready.
This is just for the record. This is the state of Georgia versus Jerry and Ware, indictment number 22 SC 185329. I know the court's aware that last week Mr. Ware entered a guilty plea in front of Judge Schwall when Miss Kelsey Jones-Connor was present. They got to the point of the colloquy where he was advised of his habeas corpus rights. And then at that point, factual basis was going to be done today, Your Honor. So that's where I'll start. So if the state was to proceed to trial, Your Honor, the state would be able to prove beyond a reasonable doubt that on April 4th of 2022, around 10:25 a.m. at the Columbia Commons apartment, which is 2524 Martin Luther King Jr. Drive, Southwest Atlanta, Georgia, here in Fulton County, the victim, Mr. Sharon, I always mispronounce this, Mr. Sharon Wade, was working. He was worked in the maintenance department at the Columbia Commons apartment complex. He was in the maintenance closet doing his job on August 4th of 2022 that morning. And the defendant, Mr. Jarian Ware, drove into the Columbia Commons parking lot towards Building 3 and began to open fire at several vehicles in the apartment, that one in which he knew or believed to know that Mr. Teyron Dorch, which is Teyron, and then Dorch is Dorche, was in. As he opened fire, he shot 12 times in the direction of the vehicle that Mr. Dorch was in. He was unsuccessful in the shooting of Mr. Dorch, but what he did do is, as he shot, the maintenance closet was in the direct line of fire. And as he shot the 12 times, he hit Mr. Wade 4 times, one in the front of his face, 2 to the left side of his cheek, and then 1 to the back of his head, as is documented in the reports, Your Honor. Mr. Wade was fatally injured in that maintenance closet that he was working that mid-morning. And as a result of the shooting, members of the Atlanta Police Department homicide team showed up. Detective Jenkins was assigned as the lead detective. Through his investigation, he received a phone call from Mr. Dorch's mother, who linked him up or indicated that Mr. Dorch could provide some insider information. In speaking with Mr. Dorch, what Detective Jenkins was able to learn was that a friend of his, a female friend, Miss Jakayla, which is Jakayla Flint, who they had gone to the prom together recently and had been friends for several years, was at Mr. Dorch's home a few days earlier, and they engaged in intimate relations, and the defendant was in a relationship with Miss Flint at that time and found out about it. And the way it was, I believe, relayed to him once he found out about it and confronted Miss Flint was that she was sexually assaulted. There was no evidence that there was any sexual assault, but that's how she related to the defendant, who then, in a fit of rage, went to go attempt to find Mr. Dorch, called Mr. Dorch that morning on August 4th, I think around 28 times. In the investigation, the detective was able to get the defendant's phone records, which placed him at the scene of the incident at the time of the shooting. And in his investigation, he was also able to speak to other witnesses, friends with Miss Flint, who indicated that the defendant had confessed to shooting Mr. Wade that August 4th in the morning, Your Honor. So had the state proceeded to trial, that's what the state would have been able to prove beyond a reasonable doubt. I believe the recommendation, and I'll put it on the record again, that was made to Judge Schwall last week was 15 years to serve on a reduction from murder to voluntary manslaughter under OCGA 16-5-1 for count 1. Count 2 would be no prost. Count 3, aggravated assault, would merge with count 1. Counts 4 and counts 5 are both aggravated assaults. 5 years to serve consecutive to count 1 for the individuals who were also in the car with Mr. Dorch when the defendant opened fire on the vehicle. And then count 5 is also aggravated assault, which would be 5 years to serve, but that would be concurrent with count 4. And then possession of a firearm and the commission of a felony would be 5 years consecutive, but suspended for a global sentence of 20 years to serve, or 25 years with 20 years to serve in custody with 5 years on the back end suspended, Your Honor. There are two members of the family of Mr. Wade who would like to address the court when Your Honor deems appropriate.
Mr. Rockwell, do you want to go ahead and go on this?
Let's hear from the family first, Judge.
Okay, all right.
And, we're going to start with Mr. Wade's daughter, Ms. Brown. I'll sit there. Sure. That way she can speak right to me. Right now, so you can sit next to me. If you'll do me a favor, just spell and state your name for the record, okay?
Okay.
We'll just direct all your statements to the court.
Okay.
You're ready.
Hello. Hello. My name is Brianna Bolden. First name Breanna. Last name Bolden, Bolden. Excuse me. Good morning, Your Honor. I stand here before you 2 years and 5 months later after my father's death for you to consider the life that was stolen from us. My father had a wife and 4 children. My older brother and 2 brothers that are younger than us and me. My older brother has 2 sons who no longer have summer visits or their grandfather. Our 2 little brothers, Corey and Landon, had their father taken away from them just a few short weeks after their birthday. Now enter kindergarten and middle school with no father to take first day pictures or walk them to class or teach them how to be stand-up men like he was. Then there's me, who moved to Atlanta from Texas to be closer to my father and my little brothers, and he was taken away from me 6 months later. In the last 2 years, I've gotten engaged and I've had my first child, which would be his 3rd grandson. My fiance couldn't ask for my hand in marriage. My son will grow up without a grandfather. I don't get to be walked down the aisle, along with many more core memories my family and my siblings and I won't ever get to have or make due to this senseless act. I stand here before you knowing that I can't have or bring our father back. But for 2 years and 5 months, while he walked free, family, friends, and myself have prayed to just bring my dad at least a little bit of justice so he could rest peacefully. And so we can finally try and start taking the steps to heal from this loss. My family and I thank you for your time spent on this case and thank you for listening. God bless.
And there's one other family member, our close friend, Dr. Peak, Your Honor. If you'll just state and spell your name for the record, okay?
Good morning. My name is Dr. China Peak. China is spelled China, Peak, Peek. I'm a close friend of Sharon's, and I also run the nonprofit organization that he was a member of. He volunteered on countless bases at the foundation. He implemented programs to teach the youth how to speak Spanish. I'm here today just to let you all know it wasn't just another working Black male that was taken. This man's family, friends, neighborhood, associates, near and far depended on him. At his place of employment, they could not communicate with any of the Spanish employees without him because he was fluent in Spanish. His family, both here and out of state, depended on him. He had 4 kids that depended on him. Not only did he take care of his family, but he took care of people in the neighborhood. He volunteered his time, and he never met a stranger. He was a person full of smile, full of joy. And even when we all would think something was wrong or something was bad, he would always tell us it is what it is. In these 2 years and 5 months, while the defendant has been able to be free, live his life, Sharon's family have had nervous breakdowns, have not been able to remove his property from their homes, have had countless hours of therapy, have not been able to throw away something as simple as the last receipt of an item that he purchased for them. We know the sentence won't bring him back, but we are hoping that at some point it can give us some type of peace and some type of closure so that we can move on. We have continued yearly to have a Love Always Day in his honor. Every year, people from near and far come together and release balloons just for the loved ones that they have lost. And this is done on his name. As his daughter said, his kids would never grow up knowing who their father was and who he could be to them. His grandson would never get the opportunity to hold his hand and call him grandpa. And the only thing we're asking is for some type of peace and some type of closure. It's been a process, and we thank everyone in the court that have had a hand in making sure that his family gets some type of peace. Thank you.
And Judge, there's nothing further from the state. I do understand that defense intends on asking for I guess, an additional turn-in date. I thought that was the time from last week to today was for. The state would object to that. And we also understand that the defense counsel intends to ask your honor to sentence him as a first offender. And speaking with the family, they just wanted to express to the court they object to him being treated as a first offender, but do understand that it's in the discretion of the court. Nothing further from the state.
Yes, Judge. What is better for your honor, that I sit, or that may I sit? Okay. Judge, as you know, this plea was tendered on, last week, and it was tendered early. We were called out to trial, actually, and, we tendered our plea early so that, the calendar would have been set and the case is behind us. We did that so for convenience sake, Judge. We also wanted to accommodate the court. So we are back here today on the sentencing, and it is a negotiated recommendation, Judge. I would first like to thank the court and thank Judge Schwall for allowing Mr. Ware to be released on bond. He was a straight A college student. He requested a bond. We had a bond hearing. We were reset for further consideration, and the Judge Schwall, granted him a bond on an ankle monitor. And he has been out without a hiccup. There were a couple of instances where the state filed a motion to revoke his bond. And one time, I don't know if there was a formal motion, but we were contacted by the state because there was a hiccup, only insofar as he was living with his godmother and there was a flood in their residence and they had to evacuate the house. The second time that there was any kind of issue with the state was when they were evicted because the landowner wanted to sell the home. Mr. Ware has never been able to work. I did secure a job for him. and it was an at-home job, but it involved him going in and doing the orientation and getting the computer, etc. So that never came to fruition. He was so concerned about keeping the bond in good status that before he took the plea in front of Judge Schwall, he called me and he said, "Would you please come with me, Miss Rockwell, to the barber shop to get my hair cut?" Because as long as I was with him and we were attorney-client, I could have gone with him, for example, to buy a suit, if you will, in preparation for the plea, or go and look at a crime scene, or go and get him evaluated, etc. Called the prosecutor. She said, "That's fine." Called the court, and they allowed that. He was that interested in not letting any kind of issues occur while on bond. You can see his family is here with him today. I'd like to introduce the family to you and have them stand up and just tell you who they are, please.
Hey, Tamara Abercrombie, I'm his grandmother.
Grandmother, you got
Yes.
great genes.
Thank you, thank you.
I'm Jacayla and I'm the mother of his child.
My name is Sincere. I'm just a good friend of his.
And Judge, we did have a little bit of a disturbance in the back there. That was his child. That was in the back corner pocket there, and it's been removed from the courtroom. He's 7 months old. And quite the center of the universe in that family. I want the court also to know that every time we've had court, he's been surrounded, Judge, by his family, his godmother, his mother has come on past occasions, and there's a great support system. I would first ask the court to follow the recommendation. And the recommendation, Judge, I think is fair. It shakes out at 25 to do 20. And I think that the state will agree that he does not have a prior record. The case was definitely a triable case. He contacted me and he said, "I'm ready to resolve this matter." And there's never a good time to change your job, build a house, have a baby, or go start a 20-year prison sentence. But he called me and said, "I'm ready. Let's go." I asked him today, I said, "Do you want to hug your baby one more time?" He said, "No, I'm good." So, suffice it to say that many, many lives were changed by this event. He is taking responsibility, Judge. I did promise him that I would ask for a turn-in date, but no matter what, I think he's ready, and he's ready to go into custody. More importantly, Judge, he does have the ability to take a first offender. And I'm not talking about right now, January of 2025. I'm talking about when his case is finished. I might not be here. I'm ready. I'm ready too, by the way. I'm not going to be here in 20 years. But I'm talking about in 20 years from now, are we going to have a kid that was in college making straight A's that's now a convicted felon? Or are we going to put him in a position where he might be able to contribute to society? That is why I'm asking for first offender. Doesn't change anything else. I don't want yet another black kid, and he's only 20 years old. He'll be 40. I don't even remember when I was 40. He'll be 40 when he gets out. And he'll have a 20-year-old child, and he'll have his entire life ahead of him. So he gets out, and some people would say, God, I didn't even think he was going to show up today. I knew he was showing up. I don't know if I'd have showed up. Catch me when you can. But he's here. He's manning up. He's ready to do what the court sentences him to. But I'm talking about 20 years from now when this sentence, well, actually it's 25, right, Mr. Abate? Because even though the 5 years that follows the 20 years is suspended, he's still technically under sentence. So I'm talking about 25 years from now. I'm talking about him doing well in prison. And if to any extent that I can, I'm going to promise him or my predecessors, if he does everything he can in prison, I'm going to find somebody to go to bat for him with the parole board. I mean, we all know what he looks at. But this is also an incentive to make him a good inmate, Judge, because you can still lose your first offender status while in prison. So my request today is based on will we have 25 years from now? He's still going to prison, he's still taking a plea, and he's still being sentenced. That is why I'm requesting first offender treatment. He is going to continue his college studies, and he's going to continue to whatever extent possible have some type of relationship with his 7-month-old child. And it might just be Zoom visitation, it might be a family day, or it might be that he gets into a facility where he's just going to be receiving pictures of his child. But he is going to prison for this, Judge, and nobody wins. If there's one thing that I can promise the family, it's that, in my experience, it's been when anyone goes to trial or takes a plea, whether they get convicted or acquitted, whether they take a plea, or whether they run and get locked up later, there's still that loss. And when they walk out the door, just like when my family walks out the door, it's still very, very sad. And you do not get the satisfaction that you think you're going to get. It's just over, thank goodness. And at some point, you pray that your heart can forgive. But this is the first step, Judge. So we tender our plea. Did you want to address the court? Did you want to address just for everything? I want to apologize to Bob Hill. Okay. And he would like to address the court. Mr. Ware, would you like to swear him in, Judge? Okay. Raise your right hand, sir. Do you solemnly swear or affirm that the testimony that you're going to give in this sentencing matter, State of Georgia versus Jaron Ware, be the truth, the whole truth, nothing but the truth, so help you God, or do you so affirm?
Yes, ma'am.
Okay, you're gonna have to speak up because my hearing aid is not in. Everybody needs to hear you. You're under oath, sir. First, please state your full name for the records.
My first name is Jim Ware, and I'm a junior.
We waived the defect, Judge, on that, and I had him sign in his correct name.
I apologize to the family, to the victim's family first. I went out there to do something that I shouldn't have been doing. I lied about it. I can't explain how it has impacted me, but I know it has affected the family as well because they got somebody who can't come back. I apologize to my family. I should just been in school, just not doing what I was doing. That's it. And he part of the family. I apologize to my child as well. I'm definitely gonna be there, but just not the way that I wanted to. But the victim's family don't have their father, just like the daughter said. I apologize.
That's it, Judge.
Anything else from the state?
No, you're right.
Mr. Ware, let me just ask you a couple of questions. What have you done or will you do to give back or to show this family your remorse and your dread and that you honor your life and others? What will you do?
It's honestly, I won't say that there's nothing I can do, but at the moment, I done been everywhere. Honestly, um, I don't think that they'll accept an apology. I don't even think that I said this to everybody because I wanted to talk to them, especially about what the situation was and stuff. But I don't. Hopefully, it's some type of remorse in their heart, or they just accept the apology that I'm trying to give because I do mean it. I shouldn't have lied. That's why I don't want to go to trial. I shouldn't have did it. It was an innocent person. I don't even know that man. I don't know him. Never seen him a day in my life. But all cause I was mad and I let just my emotions get to me. Somebody lost their life and I lost a good amount of numbers on mine. I really do hope that y'all can accept my apology, honestly. I'm definitely not the same person who I was when I went to college and when they came and got me. Not the same person. I've changed more than I could explain. Y'all can't, you all don't know me. Y'all haven't been knowing me, so y'all don't know how I've changed and stuff. I definitely, the whole situation has took a toll on everybody, me, obviously the victim's family. I feel like this, how I could,
Of the police talking about kids shooting at each other. Look, he was there shooting and he entered a plea to that. So nobody else was indicted in our case.
Do we know what the sexual assault or rape allegations were looked into? Mr.
Yes.
Bond?
it was, and they said that
What was determined is that Ms. Flint actually lied to Mr. Ware about who she was with and where she was. And then that's how all of these allegations unfolded up to where at that point she claimed she had been sexually assaulted. There was no report to the police as it relates to her being sexually assaulted, other than as being part of this investigation. And the reason that Mr. Ware acted the way in which he did, but no, there was no report of that. It was determined that she lied to Mr. Ware. After she was caught lying, she then alleged that she was sexually assaulted. So
So all of this has happened because of that, because one person didn't want to have a fight about some infidelities or what have you. You know, a completely innocent man lost his life, and let's say the other man who she had slept with was shot, and he had not, that would have been another innocent man. The people we were getting killed were innocent, period. There was no reason for these people to die. Like, I'm gonna accept this plea, get the recommendation by the state. But I'll add, no drugs, no alcohol, no weapons, no replicas of weapons. So that also applies to shanks and things like that you have in prison. So if you get caught with a shank, it's not so good. And you need to take, anger management. There's something they have at prison, something in this.
Officer Brown is online.
Oh, yeah.
Might be able to-
Yeah, Officer
to
Brown,
educate us.
sorry, okay, Officer Brown. What
Yes, Your Honor.
else you got, what would you recommend? 'Cause I'm thinking of something where he listens to different families, victims' families, and somehow this sinks in.
Well, it's not anger management. You thinking of a program in prison?
Right. They have something like victim impact, kind of like they have victims' families come in and talk to offenders and let them know, so they can kind of see where it can get through.
They do have MRT in prison, Judge,
That's what I was trying to think.
moral recognition therapy.
So anything else that you want to recommend, Ms. Brown?
No, Your Honor. No.
This is why Judge Walker doesn't come in days, because I'm just, just telling you that. Because, so to the victim's family, first and foremost. This court and the staff of this court, and I think I can speak for Mr. Abate and the state, will hold space for you. I will always hold space for you. I haven't lost family members in that tragic of a way. And I can't even speak like I can imagine how they. I don't know about closure. I can tell you losing your loved ones, and not necessarily in a horrific way, this is gonna give you the closure. And I tell you, it doesn't get easier. I think you just become numb and kind of accept. You kind of start pushing it down and kind of accept what it is. I think that that's the best way to explain it. And I'm sorry for that. I'm so very sorry for that. There's so much useless violence, and then over a girl or a boy or something like that, it's just like, what? It just doesn't make sense. I am so sorry, and I wish that I could do something to help you, although I can't. But hopefully the state can help supply you with whatever you need. Hopefully you've got counseling. I'm sorry for siblings. We'll never know their dad. And I don't want to parallel it at all with your son not knowing you, because your son will have time with you. even though for 20 years it may be speaking through glass and a phone, your son will have time. These little boys, young men, I'm sorry, young men, won't. When they're coming up, sister or uncles, if there's uncles or other male family members, have to sit down and have those male on male talks with them. She can bring your son to the prison that you're in, and you can have that father-son talk with him. But her family, that's never gonna happen. And I don't know if there's anything that, punishment or anything that makes it right. And I ask you that question, what do you think you're gonna do? I don't know, besides apologize. No, there are things you can do. You can, and I'm not talking just start acting like this when you're incarcerated. You can set your life on a different trajectory right now. Non-violence, you can get out, you can speak to young men, dating them, you can do all of that. And try to help the next person. You may not be able to help these victims, but you could probably help potential victims in the future that they not become victims, because you're gonna maybe talk to one person that's not gonna pick up a gun because of somebody lying to them or they think something happened, as opposed to letting the police do their job. And I know that's the development of the brain and things of that nature. You're older, you'll know, call the police, let's do something. So, there we go. I will make you, I don't know how long it'll take you folks. I know it won't help financially, maybe it will, maybe you can put the money, pays you folks back for the funeral expenses. I know if you don't have headstones, things like that are very expensive. And, those can be paid back, you can spend it on the boys, spend it on therapy, whatever you folks want to do, but you shouldn't be without a father, and you also shouldn't be out that money. So yeah, Mr. Ware, I'm sorry, I want you to do a ton of soul searching. Because there are things that you can do to try to make it right. As right as you can. I don't know. But that's for you to figure. There are things you can do besides just saying, I'm sorry. And I'll just point out one thing, okay, because when the family was up here, this is what I was kind of gets to. They were making you just looked ahead. But when you started hearing me talk about you, is when you got upset. And I get that. But I was really hoping to see a little bit of emotion for what happened with these. You're at a point right now, you're like, this is just about me, this is just about me, that's all. That's fine. But I hope that you have learned a lesson. Yeah, no drugs, no alcohol, no weapons, no requisite weapons, you treat the family, funeral expenses. Assuming y'all can get him the amount in some amount of time, so you can put it on there. Just, if by chance your mom or your grandma want to try to start paying that, instead of them having to wait 20 years, then you're gonna reimburse whoever pays that on your behalf. Because it's not what your grandma did, it's not what anybody, this is what you did. So if your grandma pays it or anything like that. You have any further contact with the victim's family? Unless they want to initiate it. I know sometimes they do for families, victims' families want to sit down and talk with the offender and like, why? And, have a one-on-one, that's fine. If they initiate it, you can't have any comment. If their family, friends, things like that, right? Nor can your family. Right? All I can hope is that everybody has peace. You're gonna be 40 when you get out, hopefully, because hopefully you won't recommit crimes in there. I'm hoping enough that you learned your lesson, that I will allow in 20 years or 5 years, for you to have first offender. And I hope that you make it, but being in a prison for 20 years, it's gonna be really hard. But if you do make it, that's gonna prove to this family that you meant the apology that you gave them. That you don't get so wrapped up in yourself there, that you just want to do right so you can see your son and prove to them, I've changed my ways. I'm not getting in any trouble, I mean, anything. And give them the right to revoke the first offender. Because I don't want you to be another statistic. Okay?
Yes, ma'am.
Great. And so I'll accept the recommendation, and this has been freely and voluntarily given. With a full understanding of everything you pled to, am I right?
Yes, ma'am.
All right. Maybe we go ahead and take off your watch and all that stuff.
Judge, let me ask you one thing. If you are granting the first offender, correct? And you did talk about funeral expenses, correct? If that gets on a sentence, there needs to be probation.
Yeah, okay, yeah.
And secondly, could we have an amount?
Not necessarily. It could be paid directly to the ADA.
To the ADA.
I think it's better if it's done through probation because in 20 years,
Yeah.
Mr. Abate and I will be on the beach.
I won't be there.
I think that it has to be probation if he gets first offender. It can't be, okay. So Judge, you do have to modify 20 plus 5.
Okay, and then the 5 on probation.
20 plus 5.
It would be consecutive probated instead of consecutive suspended.
So 25 to serve 20 years
To serve
to serve plus 5
5 years.
probated instead of suspended. April?
Does that sound about right? I don't want you folks to, I mean.
No, that's the only way I think you can
No,
do it.
I'm asking, does that sound about like it was the cost? Financially, not the emotional cost. I'm sorry, what was that? That 20,000, does that sound about? Yeah, that's fine. That's it today, 20 years down the road, so, okay, then 20,000,
So my question is, we'll all be retired. Is 5 years enough time for this young man to come up with $20,000?
Well, the minute he gets out of jail, if he gets granted parole, he's still under sentence and he can start with his obligation.
While he's under parole. Okay, if he's parole.
Otherwise, he's got $4,000 a year, which is about $360 a month for the restitution. Right?
If he's paroled, he'll still be under our supervision.
what was that, Ms. Brown, I'm sorry?
If he's paroled, he'll still be under our supervision.
Okay, right. So I guess if it's coming down to the wire and you don't have it, or go to the bank and get a loan for something. But these folks are gonna get paid back.
And I have anger management, evaluation and treatment.
Right.
And you mentioned MRT, but you didn't say.
Yeah, it's like,
Moral recognition therapy. But to the extent that he can do any of that in jail or on parole, then he doesn't have to redo it while on probation.
he submits proof that he did this while he's incarcerated.
So he's gonna have to get reporting instructions, at least verbally. But let's say he gets paroled, the same officer that supervises him will say, okay, your sentence is over. Now you're starting your probation and you have to make sure this, and this is done. To the extent you did that when you were at Rogers CI, here's the certificate. To the extent that you start paying the minute you can pay, then he's working away at it. But if he wants the first offender, he has to be on probation.
We're doing probation, right?
And since we're doing first offender, I don't believe during the first part of the plea that was done last week that the first offender questions were
Okay, you
opposed
need to
him.
ask him.
So, Mr. Ware, do you understand you're asking through your counsel to be treated as a first offender under the provisions of the First Offender Act?
Yes, sir.
And have you ever pled guilty or nolo contendere or ever been convicted of a felony in the state of Georgia or anywhere else?
No.
Okay. And has Ms. Rockwell explained to you the benefits and pitfalls of the First Offender Act?
Yes, sir.
Okay. And do you understand that if you violate the terms of your first offender sentence or commit any new offenses while on first offender probation, that your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced to or up to the maximum sentence for each charge that you're pleading guilty to in the indictment?
Yes, sir.
So do you understand that the additional aggravated assaults for the additional victims that didn't merge with count one, where you received a 5-year sentence, you could be resentenced up to the maximum, which is 20 years for each one, which would be an additional 40 years?
Yes, sir.
Okay. Ms. Rockwell, in your speaking with Mr. Ware, do you believe that he understands the First Offender Act and the benefits and consequences as it relates to first offender if he violates the sentence?
I do.
Okay. And I believe also, Mr. Ware, you need to be informed that you have 30 days from today to file a direct appeal from this guilty plea. And you have until the end of the term of this court to file a motion seeking to withdraw this guilty plea. Doesn't mean that the judge would grant the withdrawal, that you just have the right to do so. Ms. Rockwell would be the attorney who would represent you or file those motions unless she sought with the court not to do that. And then you would be an appointed lawyer to do both of those things within the time constraints that I just described. Do you understand that, sir?
Yes, sir.
Okay. Thank you, Judge.
What about the habeas corpus rights?
She read them.
I understand. Judge, just to the extent, Madam Case Manager, Litigation Specialist, if we could just put the amount of time that he served prior to making his bond.
So 2022, March 7th, 2023. That's what's on the system, or I can allow the Fulton County Jail to do their, they're gonna do an affidavit of custodian.
I prefer that we also put the days, if the state has any objection to that on the sentence.
It's gonna be one or the other.
I prefer the days
Okay.
to be placed instead of us trying to get an affidavit. Madam Probation, are you going to give him reporting instructions?
I do have a couple requests though. Due to the live streaming, I would prefer for you to gather information and provide it to me via text. A phone number of a family member. I need emergency contact. I need an address. And from the prosecutor, I do need victims' information for payment.
Yes, ma'am.
I need address, phone number, of course, name, and the exact amount so I can put it on the sentencing paperwork. And that the report instructions can be provided to the family member that you provide to me, Ms. Rockwell.
And you can email it to me also,
Okay.
the reporting instructions. You can email it to me.
Okay.
Anything else?
Nothing further, Your Honor.
So much, Grandma, if one of you are paying on that before he gets out, somehow keep record, let us, so that probation or whatever, okay? All right. Thank you so much.
Thank you, Judge.
Then down so you can get your address key.
Yes.
Ms. Brown, do you have his social, et cetera?
Yes, I do. I just need a family member's phone number, contact information, address, a parolable address if possible.
No,
And Judge, thank
Can
you
y'all
for
bring
filling
his
in that.
books for him?
Yeah.
Nice to see
No,
you.
you cannot be excused, prosecutor. I need the victim's information.
Tate?
And Mr. Tate, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 27, and I have graduated from undergrad. I'm starting grad school soon.
Okay. And are you able to read, write, and understand the English language?
Yes, without a doubt.
Your Honor, for the record, the state is null pricing count 1 of this indictment, which is aggravated assault, family violence, and count 5 of this indictment, which is criminal trespass. And we're moving forward with false imprisonment, count 2, count 3, possession of a firearm during the commission of a felony, and count 4, battery, family violence.
Okay.
Mr. Tate, do you understand that you've been charged with aggravated assault, family violence, false imprisonment, possession of a firearm during the commission of a felony, battery, family violence, and criminal trespass, which the state is null pricing counts 1 and 5, leaving false imprisonment, possession of a firearm during the commission of a felony, and battery, family violence?
Yes.
Do you understand? Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, I understand those rights.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Absolutely.
Counsel, do you waive formal reading of the indictment?
We do.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
We do.
Mr. Tate, have you been arrested on these charges?
Yes, ma'am. I was arrested in December of 2019.
Okay. I asked because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
There are none.
Okay. Mr. Tate, has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
For false imprisonment, the minimum is 1 day to serve, the maximum is 10 years to serve. For possession of a firearm during the commission of a felony, it's 5 years to run consecutive to any other count. And for battery, family violence, the minimum is 1 day to serve, the maximum is 12 months to serve. Do you understand?
Yes, ma'am.
Do you understand this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of, for count 2, false imprisonment, 2 years probation. For count 3, possession of a firearm during the commission of a felony, 5 years probation suspended to run consecutive to count 2. And then for count 4, battery, family violence, 12 months probation to run concurrent to both count 2 and 3. Special condition that you have no contact with the victim in this case, Miss Giovanni, Giovanna, last name Lucas, Lucas, and complete the family violence intervention program. The judge doesn't have to accept this recommendation from the state. The judge can sentence you to the maximum on these charges and can run those sentences consecutively or one after another. Do you understand?
Yes, ma'am.
Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would, and this is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or your ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or the court-appointed counsel if you cannot afford an attorney, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am, I understand that.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, it's my decision to waive my rights.
And enter a guilty plea because you're in fact guilty?
Yes, ma'am.
Okay. In indictment number 22 SC 182090, how do you plead to the charges of false imprisonment, possession of a firearm during the commission of a felony, and battery family violence?
I plead guilty to those.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, this is free and voluntarily given.
Do you understand that you only have 30 days from today to appeal this guilty plea conviction?
Yes, ma'am, I understand. I have 30 days to appeal this guilty plea conviction.
And do you understand that you only have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging challenging the constitutionality of this guilty plea?
Yes, ma'am.
Okay. Thank you. Your Honor, the state is aware of one prior conviction by the defendant, which is a conviction that he took out of the state of Louisiana, the city of New Orleans, back in 2018. Those charges were reduced from, Your Honor, if you're interested in the charges, I'll tell you they are not the same as what was charged in this case. And I think that defense counsel will probably want me to waive sounding on those charges. But if you want to know what those are, I will convey that to the court.
I'm assuming they're CWAC.
Yes, Your Honor.
Okay.
Okay. And had this case proceeded to trial, Your Honor, the state would have proven beyond a reasonable doubt that on December the 10th, 2019, our victim went to the APD office and spoke with the officer about an incident that happened between her and the defendant, Mr. Taylor Tate, on December the 9th, the day before. There was a dispute between the two, which became physical when Mr. Tate decided to strangle Miss Lucas, who is the victim in our case. At some point in this physical attack, he also pointed a gun at her. He threatened her, and he also tied her up with what she described to be either cable cords or a game system cord, joystick cords. At some point, she was able to get free from her being tied up by these cords. She ran outside of the apartment that they shared together and tried to get the help of a neighbor. The neighbor did come outside to help, but that neighbor also appeared with a shotgun, which kind of startled our victim. She ended up going back inside this apartment with the defendant, Mr. Tate. At which point, the next day when she was able to get away from him, she did go into APD and report what happened. She did have visible injuries over her entire body. I saw the pictures of those injuries, Your Honor. The injuries consisted of being on her back, her arms, her legs. She even had bruises on her face. There were also text messages in this case that if we did go to trial, the state intended to enter into evidence where is communications between the defendant and our victim, Ms. Lucas, after this incident occurred, where he's basically apologizing for his actions. She told him that he tried to kill her. He tried to suffocate her and tied her up. He admitted that he was playing and this was a game to him, and that he apologized that she didn't take it that way. This has been a case that's been open in our office for 6 years now. Our victim is on board. She was ready to prosecute this case if that was needed. But me and defense counsel we've talked quite extensively trying to come up with a resolution that works for everyone. This is the most appropriate thing that the state could come up with, especially since the defendant did have a prior conviction and basically had already had a second chance. The victim, Ms. Lucas, she does not wish to make a statement. She just wishes that the defendant continues to not have contact with her and continue to go their separate ways. That is all from the state, Your Honor.
Mr. Adams?
Judge, this is being put forward as a negotiated plea. And so I'll start from the back and ask that the court accept the recommended sentence as put forth. As Ms. Hall has indicated, we have had extensive discussions about the case. Case has gone through about 4 or 5 different hands. And so I've had discussions with several different assistant district attorneys with an attempt to possibly resolve the case. Mr. Tate is 27 years of age. He was born in New Orleans, grew up in New Orleans, graduated from high school in New Orleans in 2015, subsequently attended and graduated from Clark Atlanta University with a degree in business supply chain management. He is currently employed, works with HD Supply, it's a subsidiary of Home Depot, as a supply chain analyst, worked prior to that with Accenture as a manufacturing consultant. Now, we agree that there is a factual basis for the entry of this plea. I believe for the case to go to trial, there would be a lot of elements in dispute. But at the end of the day, I think that there is a factual basis. I will tell you that, and I will be candid and share with you that in 2014-15, when Mr. Tate was a senior in high school, he was arrested based on an interaction with a young lady who had spent 3 days with him. He was ultimately charged with sexual assault. The case was reduced and he pled to a charge of video voyeurism. Essentially, what the allegation is that he took pictures of a young woman after he and she had been intimate and shared those pictures with other individuals. That is the element that he ultimately pled guilty to. It shows as a felony. And what Ms. Hall was referencing was that we had discussions about whether he would plead to a misdemeanor in this event, or whether he would plead to a felony and be eligible for first offender. I could not determine that. My determination was that it was a felony offense in Louisiana, which made him ineligible for first offender here. In regards to this case, the named victim, Ms. Lucas, was a longtime girlfriend. They were in a longtime girlfriend-boyfriend relationship. There was an incident that occurred on the date listed in the indictment. Our contention, and again, we believe there's a factual basis, but I do want to at least put it in context that our position has been and always and remains that there was a dispute between the two of them and it turned into a mutual fight, essentially. We think that if it had gone to trial, there'd be some evidence that Ms. Lucas grabbed the knife, that Mr. Tate, who has and illegally owned a gun, grabbed the gun. He ultimately put it down. She grabbed it, and he grabs her hand and bangs her hand to try and get her to drop the gun. She runs into the bedroom. He runs after her, kicks the door. The door comes off the hinges and hits her in the head. Everything calms down after a while. They spend the night together. The next day, she goes to work, and after she comes home from work, she goes to the police, or leaves work, goes to the police, and makes the report. Mr. Tate was arrested. He was very distraught at the time. I was in a bad place mentally. There were some text messages back and forth where essentially she's saying, "You did this to me. You tried to kill me. You put a gun to my head." And Mr. Tate's downfall is that he doesn't deny those things in his response text messages, although his account is that there were many other things that happened that weren't reflected in those text messages. That being the case, we've discussed it. Well, we go to trial. What a jury sees is what's actually in those text messages as opposed to what you didn't put in the text messages. So they don't get the whole account other than from you. But there is enough there that if the case were to go to trial, he could be found guilty of those offenses. I've represented him from the beginning, represented him through a temporary protective order hearing, and from then till now, 6 years, 5+ years old. He has moved on. She has moved on. I think that the young man is in a place where he is a much more mature person than he was 5, 6 years ago. I think if he were the person he is today, back then, we wouldn't be here, right? But I guess that's probably the case with everyone who's young and matures and learns better. So I say all that. I know I didn't need to, but I kind of wanted to give you a little bit of context to everything that's happened here. He's not been in contact with her, doesn't have any intention of. And so I'm going to ask you to follow the recommendation that's been put forward, give him an opportunity to continue in the positive direction that he has been since then. I could give you a long list of all the community service he's done in the past, 4 or 5 years. But ultimately, I'd still be asking you just to follow the recommendation.
Anything else, Ms. Hall?
Nothing further from the state, Your Honor.
I don't know whether medical bills.
No, Your Honor, not that I'm aware of.
Yeah, there were no significant injuries. She didn't go to the hospital.
Okay, all right. Where are you in grad school, Mr. Tate?
I'm starting grad school soon. I didn't actually apply yet. I'm looking at different universities, possibly Emory or LSU.
All right, so what's anything from probation?
I have nothing further to add, Your Honor.
Okay, so we'll go ahead and add my standard, no drugs, no alcohol. And then no drugs unless prescribed, no alcohol, no weapon, no replicas of weapons. And I'm assuming that you guys do compliance for the FFIP program. Ms. Brown?
I'm sorry, say it one more time.
I guess you guys have compliance for him completing the effective violence intervention program, correct?
Yes.
Oh, okay. And Mr. Tate, just so you know, that there's one that I think a lot of gentlemen I've had to make overdose, men stopping violence. They like it, they do count, there's people that have attended those that are mentors there, so there's several places you can do it. I'm sure Mr. Brown will have a list. But I'll go ahead and take this as freely, knowingly, voluntarily, and with the understanding of the penalties that do not take this plea and the understanding of the skill. So I'll set this plea to go to the court. Thank you, sir.
Thank you, Your Honor.
Thank you, Judge.
Thank you, Ms. Harrell. Anything else, Ms. Brown?
I am at this moment texting the reporting instructions to the Cobb County Probation Office on January 23rd, and that's the date. And nothing further, Your Honor. I received all the information I needed.
Okay, so you don't need anything else from him?
No, I don't.
I'm sorry, Madam Probation Officer, does Mr. Tate need to contact you or will he receive a communication from you?
He will report directly to the Cobb County Probation Office on January 23rd.
Will you send us reporting instructions and location and so forth?
I just texted to the defendant's phone and I will also text it to you.
Thank you.
You're welcome.
Now,
Did you get the text?
oh, let me check. Oh, yes, Your Honor, I
Okay.
received the text.
All right. Thank you, Ms. Brown. Anything else?
You're welcome.
Thank you.
Now, may I please say something?
To the court?
Yes.
Sure. What, do you want it on the record or off the record?
Surely, either way is fine. I just wanted to, if I could, just take the time to, apologize for all of the time spent on this. I understand that this is, our tax money and people's tax money put to work, and all of you work really hard to try to find the truth. And sometimes, though everything is not what it seems, you do your best. And I just want to say I appreciate everyone involved for doing the best that you can. So thank you.
Thank you, Mr. Tate.
Thank you, Mr. Tate.
All right.
All right, that's it.
That's all, Judge. May we be excused?
Yes, sir. I really did.
It is good to see you. Take care, please.
Glad you can use the elevator to come up the first floor.
Almost forgot that there were courtrooms above the first floor.
Right.
Your Honor,
Ms.
that also concludes my business. May I be excused?
Yes, ma'am. Thank you.
Thank you.
One lie, one moment of rage, and an innocent man never made it home. But after 2 years of waiting, would an apology be enough? That's the heartbreaking question at the center of this emotional courtroom sentencing. The defendant stood before the judge after accepting responsibility for a shooting that was never meant for the man who lost his life. According to prosecutors, he went looking for someone else after believing his girlfriend had been assaulted. He fired multiple shots into a vehicle, but instead of hitting his intended target, the bullet struck an innocent maintenance worker who was simply doing his job. The victim died at the scene.